most people taking this course are never going to work a day in their life in a newsroom. But many of you will wind up being in a public relations firm or an ad agency or inside of a corporation where you're responsible for their campaigns or their social media. And for those of you who are going to go into that line of work, it is immensely important that you understand the rules and regulations that apply to that field and what you can and can't do and what will and will not get your client in trouble. And for that, I have brought in a bona fide expert who deals with this every single day, Natalie Harris. Natalie Harris is the Harris in the Baron Harris Healy Law Firm in Chicago. She's a frequent speaker and contributor to the Media Law Resource Center, where you can read a lot of her columns about contemporary media law issues. And she advises clients on compliance with the regulations that affect the communications industry kind of writ large. So she's a graduate of the University of Wisconsin Law School, and I'd love for her to share a little bit more about her interesting and unique practice and kind of what a day or a week in the life of the Baron Harris Healy practice looks like. So thanks, Natalie.
Thanks so much for having me, Frank. I really appreciate it. I know we were talking offline before, but I always do like the opportunity to talk to people for whom what I do is new and interesting, people who are sort of blank slates and don't already have kind of an idea in their head of what it means to be a lawyer, particularly what it means to be a media lawyer. So my story is a little offbeat, which I think is good because I think generally more and more as time goes on, lawyer stories tend to be more offbeat. There was a time in this country when most lawyers looked the same, came from the same background, and had a fairly similar path, and they just wound up deciding which firm to work at or whether they wanted to work for the government. But my story is a little bit different. As you mentioned, I did go to the University of Wisconsin. I took a year off in between undergrad, where I was at the University of Michigan, and I spent time in Japan. And I taught English in Japan. And while I was there, I sort of, fell in love with it. And I had taken Japanese as an undergrad. And when I went back to Wisconsin, I really missed sort of the Japan element of my life. So I did take a semester of law school and go abroad to Temple University in Japan. And there I met the 5 other people in the world who had a cross interest in law and Japanese culture and language. And they thankfully were able to point me in a good direction for an initial career path, which was at a firm in Chicago called Masuda Funai, Eifert and Mitchell, that focused on servicing Japanese companies, which I did for a couple of years. But the big sort of break in my career, I would say, came when I got cold called, which doesn't happen much anymore, in about 2004 to work for a boutique in Chicago called Mandel Mankis, and their specialty was defamation defense law. And that's where I really built up my career. One of the partners, the name partner, Steve Mandel, really took me under his wing and taught me sort of everything that you need to know to start a practice and to service media clients, all kinds of clients, from journalists, authors, publishers, broadcasters, playwrights, podcasters, anyone, and also on the commercial side too, advertising agencies, that sort of thing. We did every kind of project that you might imagine, from the front end where you do counseling, people present you with things that they want to publish, investigative stories that are going to go out, ad campaigns that they're thinking of, and it's your job to vet them, take a look and say, what in this content is risky, what might draw a claim, what might cost the creator down the road, and advise them. And then on the other side of our practice is litigation defense. And we often like to say that if you haven't come to us for the first part, where you got your material vetted and you find yourself on the receiving end of a lawsuit or a claim, well, we're there to help you there too. We've specialized in doing defamation defense and other kinds of litigation, always on the defense side. So we almost never bring a lawsuit. We're always defending someone who has been sued, and the bread and butter of our practice are suits that arise from some kind of media content. Like I said before, an advertisement, a movie. I just finished a case, settling a case in Wisconsin. I'm licensed in Wisconsin too, arising from a movie called The Giant Spider Invasion, which is an old B movie from the 70s in Wisconsin that was riffed by the guys who do Mystery Science Theater, which is probably too old for your class, but was sort of cool for me in college. They do voiceovers over movies. And anyhow, the original director and owner of the film was not pleased about the Mystery Science Theater folks, they're now a new company, continued use of the film. So that's a kind of litigation we would do, and also just a traditional defamation. Someone writes an article, says something factual about somebody, that somebody is not happy about it, claims that it damages their reputation, and files suit. So I did that for years and years, and about 18 months ago, me and two of my longtime dear partners, Steve Barron and Brendan Healy, or the other names in our firm, decided to branch off and create our own firm. And we do very much the same kind of work that we have always done. We sort of do it our own way, just a little bit differently. We have more of a sort of what I would call client-focused practice. And we've each sort of developed a specialty area. I tend to like to do the litigation. And I've had a few cases this year that involve defending victims of either sexual abuse or assault or other kind of workplace harassment who have spoken out and then been the subject of defamation or other similar claims based on speaking out. And I've defended those folks to basically establish the truth of the things that they claimed and to shut down the predators who have filed suit and are trying to silence them. So I spend a lot of my time writing briefs, not so much going to court right now because COVID has made going to court kind of a thing that happens just like this is happening, but courts are still open digitally. So I have had hearings, I've had briefings, I've had appellate arguments even during COVID. And I also just field a lot of calls. Clients who are repeat businesses, like little ad agencies, will ask us, you know, hey, can I use this mark in my new campaign? Is there a risk if I put this out there? I've got a TV group client that'll call me and say, hey, we're running this story. Will you take a look at the video and the script and let me know if you've got concerns about the way they're saying anything? So every day is a little bit different. But every day includes usually a lot of writing, definitely some phone time, and a lot of strategizing. What's coming next? You know, what's the next thing I have to prepare for? And do I need help from my other partners or other of counsel lawyers, you know, preparing or getting work done for deadlines?
Yeah, so I hope that folks who are watching this are picking up on a couple of things. First of all, picking up on just the breadth of knowledge that you have to do this work. I mean, what you described just over the course of this last couple of minutes really touches on almost every subject area we'll study over this course: copyright law, defamation law, First Amendment freedom of speech, advertising and commercial speech, right? All those things are things that you may touch in the course of a week or a month in your practice, and you've got to be able to recognize the issues and spot them in each of those, as do your clients have to be aware enough to pick up the phone or email and to say, Natalie, I think I have a legal issue here. Can you help me out? And that's the other thing that's so important for people to understand about the role of lawyers is the 90% of the iceberg beneath the surface of the water that we never see is the stuff that happens outside of the courtroom, the stuff where you're counseling and advising people about the avoidance of disputes so that it never gets to the 10% that we see.
Absolutely. I think that's sort of a misconception or a thing that you don't really ever learn about, at least in the old days, until you show up in the office. You realize that lawyering is not TV lawyering, that much of it is really unsexy, slaving at a desk, writing, researching with a pencil in your ponytail, you know, trying to find answers so that you can eloquently, you know, give someone good guidance and then hope that that it holds and that a suit doesn't follow.
So I'm going to invite you to just dive in and share some of the kind of recurring commercial speech issues that you encounter in your practice. And just by way of setup to that, you and I have talked about this a little bit, that this is an area that people don't learn in their American government class. They don't learn it in their civics class. There's this whole sector of the government within the executive branch, the rulemaking agencies, that are so unfamiliar to people, and maybe understandably so. There's this confusing alphabet soup. Wait a second, what's the difference between the FCC and the FTC again? Slow down, go over that again. Understandable. It's very hard for a layperson who doesn't do this work all the time to keep track of it, but it's really important if you're going to be in any kind of a communications business at all, and increasingly who's not in a communication business, to know at least a little bit about your rights and your responsibilities. So go ahead and dive in and take us through it.
Sounds great. I'll do that. Thanks, Frank. And I think you make a really good point about sort of the lack of education and the various steps towards becoming a professional with respect to agencies. I will say that it took me a long time, even after practicing, to have a sense of which agency has an impact on what industries and how, and the interrelationship. And it's really confusing. So I feel like the students will be watching this are actually pretty lucky because they'll be getting at least the first building blocks to understand how that works long before, most professional people do. So here are just a few things that I thought I'd cover. The first thing talks about what's the Federal Trade Commission. That's sort of the biggest alphabet soup member in the world that I tend to live in. And I'll break that down just a little bit to talk about the FTC is a giant agency. If you go on their website, your eyes will spin just out of the blocks. And keeping in mind that's one of how many hundreds gives you some sense of just the breadth of the administrative government. But there are a couple of narrow rules that fall under the FTC umbrella that I think are interesting and sort of bear on practices that deal in communications. Then I'll move on a little bit and talk about a couple real high level other general legal frameworks outside the FTC that sort of impact the kind of work that I do and impact my clients that they need to be aware of or that I need to remind them of repeatedly because they, present some sort of risk and guidelines for the kind of work they do. And at the end, I just have a couple sort of fun cases just to show how this stuff plays out in the real world, which is another thing that if you go to law school, I think it's better. But back in the day when I went, and maybe when you went, Frank, making it applicable to every day was not the strong suit of legal education.
Not at all. Yeah, but no, let's bring it right up to the present. That's why you're here. Yeah.
All right. So first topic here, what's the FTC and why do you care? Well, maybe you don't care, but I'll tell you what it is anyway. So the FTC, that's the acronym for the Federal Trade Commission. And as I said, it's a massive agency and it has multiple functions. One of those many functions I've talked about here is basically consumer protection. And it's the agency sort of charged with policing unfair, deceptive, or fraudulent trade practices that are commercial. I would say, the typical sense of what the FTC is sort of the scam patrol. They look for and try and shut down operations that are scamming the public. I always used to say sort of the people who'd walk up and try and tar the driveway for an old person or give them a new roof. That kind of scam is sort of the bread and butter of the FTC. Pictures here at the bottom talk about ones that are top of mind now. There's forever a new weight loss scam where people are screwed out of their money for, snake oil. Some of the two hot things, for better or for worse, over the past year or so has been CBD, which is the non-hallucinogenic property in cannabis, which has been marketed, I'm sure everyone who's sitting knows, for just about anything you could ever imagine. Headaches, feed it to your dog, he'll calm down. And so there's a lot of policing that needs to be done with respect to unsubstantiated claims about CBD. And sadly, in the past year, there's been a spike in sort of fake remedies for COVID, which is really sort of preys on vulnerable people. So that's what I would say most people think about when they think about the FTC. But if you're someone who lives in the world of media, then, that part of it, while important, is maybe not the biggest focus. What the things that really touch on what I do mostly stem from what we call, which is sort of known as Section 5. And Section 5 is sort of the magic part of the FTC's act. And the main point of Section 5 is to prohibit unfair methods of competition and commerce and unfair or deceptive trade practices. So that's such a broad concept. It's almost impossible to define, but if you take away nothing else, know that Section 5 of the FTC Act is sort of to prevent false advertising, or sort of the scam version in advertising. Two things that I think are interesting that fall under that umbrella are, one, this concept of native advertising, and second, the concept of testimonials and endorsements, which is sort of a nerdy lawyer regulatory way of referring to influencers, although we didn't know that's what we were talking about until recently. That is what we're talking about. So let me talk a little bit about both of those so that folks have a sense of what they mean and why they matter.
Yeah. And by the way, I mean, just to interject,
Sure.
people may be wondering, why do we study consumer scams in a course about media and communications law? And the answer is, as Natalie is explaining, because so much of the regulation is not about, is this a good product or is this not a good product? It's about how it's communicated. It's about how it's represented, about how it's promoted, about how it's marketed. So a lot of the federal jurisdiction is less about, is this cannabis oil any good or not? More and more, especially for FTC land, is more about how is it being represented, how is it being marketed, how is it being offered and sold to people.
Absolutely. I think it's an interesting intersection between sort of communications, PR, journalism, and consumer protection. And I think before you do the work in the field, you don't realize how interconnected those things are. But after you spend some time, you realize that really sort of staying out of trouble, protecting your clients and doing the work well, really it's incumbent on anyone to be aware of the consumer protection element and the sort of the goals of transparency and accuracy vis-a-vis the reader, the consumer, the public, citizens. And native advertising has been sort of hot button for the past couple of years. Basically what native advertising is, I always like this quote in the middle. This is from an advertiser who's trying to market native advertising. They say native advertising is a non-intrusive ad format that's based on integrating an advertisement into the natural editorial style or content of a website or news platform. So really what native advertising is an ad. So it's commercial speech, it's paid for speech. It's something that's trying to sell to the public, but it's sort of disguised as something editorial, made to look like news, made to look like something hard and fast objective fact, when in fact it's not. It's got a sponsor that's paying for it, and that needs to be disclosed to the consuming public so that they are aware that what they're reading is not fact-based editorial, but it's commercial speech and that they're trying to be influenced. I always love this example here. This, I think it's fairly recent. It just shows so nicely, what is a classic piece of native advertising. If you look at this, it looks like, to someone who's not being careful, it's a New York Times, possibly an article, right? It really is meant to look and feel like a standard editorial piece about birds and their benefit for the environment, the risk of climate change. And if you're flipping through the New York Times, or if you're paging through their site and you see this, you're apt to believe that this is a New York Times article about birds. In fact, that's not what it is at all. And you're alerted to that because the New York Times has been careful about making sure they disclose to the consumer that this is in fact a paid post. Notice they make it as small as possible to comply with the rule, but it is there. In fact, this is an ad. This is an ad by Allbirds, which is a shoe company, and they've hired someone to create this very appealing piece that looks like a piece of news to sell their brand, to sell their shoes. They're making the connection between their brand name, Allbirds, and the actual sort of environmental angle of birds, and they're trying to sell their message as a sustainable company. So this kind of advertising, native advertising, where it's blur between hard news editorial content and paid content, is a real area of regulation for the FTC. They want to make sure that consumers are informed through things like paid post disclosures when content that they're viewing is not traditional editorial content and is sponsored content. The other category of content that falls under the umbrella of FTC that crosses my desk a lot are the testimonial and endorsement guidelines. And they also sort of fall under Section 5 as well. And I think most people now understand this in the world of social influencing. When I first started out, or when these first came about, it was more in the world of sort of Yelp reviews. That was the kind of testimonials and endorsements. And even before that, my guess is kids in the class are not even going to be aware of these, but, sort of doctor ads or, where you'd have someone literally doing an endorsement sort of infomercial for a product. But it's really evolved now, and it's become important and applicable to the world, particularly of digital advertising. It's really this idea that if a blogger, or a social influencer is promoting a product or service based on some kind of material connection that they have with the underlying brand, either they got it for free or they're being paid, that fact has got to be disclosed to the consumer. It is not okay for an influencer or the brand, and the brand will be on the hook for this, to promote, to endorse, or to give a testimonial. I love this, I use this, and it doesn't have to be that direct either, without disclosing to the public that the reason or one of the motivators for their opinion is the fact that they got the item for free, they've been asked to give a nice testimonial or endorsement, they've been asked to use it, or most importantly, they've gotten paid to show it to you. So that's really been kind of a burgeoning area. And I find it comes up quite a bit in some of the work I do. I help clients with like sweepstakes and contests, and often run on digital platforms. They'll want people to retweet a photo, endorsing the brand. And that is really, under these guidelines, a testimonial. It's an endorsement. I love Big Macs. It's not necessarily their own experience. And so if they are posting a photo or giving an opinion on behalf of the brand, or if they've been incentivized by the brand to do that, these rules require that that be disclosed. It's hard to do on Instagram. You'll see like hashtag sweepstakes, that sort of thing. That's the reason those things come up, is because that's the mechanism that's developed to make those kind of disclosures.
Yeah, and it's important for people to understand who see those kind of influencer disclosures like you're showing, right? This is not just a matter of the platform's policies or platform standard. This is federal law. You can get in trouble with federal regulatory agencies. So yeah, there's some things you do because the platform would prefer that you do it as a matter of their standards, but there are some things you do because the law makes you.
Absolutely. And I think sometimes people underestimate, the power or reach of the law, and they think, well, I'm not a big brand, no one's going to ever come after me. And when I go to conferences of other people, who do this kind of work, there's always sort of the horror stories of the year. And this was one that came up rather recently. This is the FTC did file what they call an enforcement action, which is their version of a lawsuit, against this brand of mosquito repellent that recruited athletes. I'm not sure if your folks know Carly Patterson, she's a gymnast. This was during the Zika virus times. They recruited Carly Patterson and paid her quite a bit to post on social media to make it look real organic, like she loved their product, and tweet about it. But in none of the content that she posted did they require her, or did she disclose the fact that she's doing all this because she's a paid spokesmodel, basically. So the FTC went after them. And normally what happens when the FTC goes after someone is they file a complaint. You don't really ever beat the FTC. So it usually winds up several months later, after a bit of investigation, in a settlement that requires you sometimes to pay the company to pay money and to put in new practices in place, to sort of be on probation, if you will, to make sure that you include disclosures going forward. So that's sort of the end of my FTC part. I was going to talk real briefly about just a couple other areas of law that touch on the kind of work that I do. The first one is the Lanham Act. And if you talk to most lawyers and you say Lanham Act, they'll say, oh, that's the Federal Trademark Act, which it is. So the most cases that are brought under the Lanham Act have to do with trademark infringement. In other words, you use my logo or the name of my brand without my permission, or you use something that looked just close enough or like what I was doing to hurt my sales. This is a little bit different. This section of the Lanham Act is called 43A. I don't know, I guess lawyers like to refer to things by their numbers, but 43A is sort of a federal false advertising statute. And it really is the federal prohibition. So it's an actual law that has a private right of enforcement, meaning that a company can sue a company for violating 43A. That's not true with the FTC Act. The FTC has to enforce it. There's not a private right of action. But for 43A, there is, which means that a company or a brand mostly can sue another brand for false advertising based on the Lanham Act. And this picture that I have here is sort of a famous case for a lot of reasons, but I just always am fascinated about the millions of dollars and the near decade of litigation that arose from the fact that the Minute Maid folks used the tagline enhanced pomegranate blueberry flavored 100% juice blend. And Palm's claim was, no, we actually sell true pomegranate and blueberry juice. What you're selling is kind of apple and grape juice with a little bit of blueberry and pomegranate. People are buying yours thinking it's as good quality and the same percentage of actual pomegranate and blueberry as ours, and they're being deceived. Had they known, had you accurately disclosed that you were really an apple and a grape juice, not really a pomegranate and a blueberry juice, those sales would have gone to us at Palm and not to you. And that case was litigated all the way to the Supreme Court, came all the way back down, and eventually went to a jury trial, which is also fairly unusual for a case like this. And Palm lost. The jury said, I don't know, Palm, I don't think so. While it may be true that Minute Maid wasn't exactly clear about how much actual pomegranate and blueberry they had in their juice, I just don't buy it that had they been clearer about it, you would have gotten their sales. So that's a perfect example of the ridiculousness of litigation.
Yeah, well, and just to pause on that for a second, because brings up two important points worth emphasizing. You mentioned the key is material misrepresentation, material deception, material meaning in a case like this, likely to influence the purchasing decision. So if something is just an insignificant misrepresentation, it's not going to result in a loss. The other thing for folks who are kind of the law geeks out there, you had the reference to interstate commerce, and we'll see that from time to time over the course of class, interstate commerce, interstate commerce. All that means is that we're talking about the US federal government here, right? US federal government doesn't show up at mom and dad's candy store to regulate how mom and dad are selling candy. They only get involved when somebody is doing a substantial enough amount of business that it actually has some interstate importance or impact on it. And it doesn't have to be a whole lot. It doesn't have to be as big as Minute Maid, but it's got to be more than mom and dad's candy store in order for the federal government to have jurisdiction over it. So just emphasizing that's why that's there.
That's a really good point. And I think that's another just sort of rule of the road that is never very well explained to a layperson, you know, in a regular liberal arts education, the difference between the federal system that requires sort of interstate action for there to be jurisdiction and the separate, completely separate state system that don't necessarily overlap, although they do in the courts, but it's very complicated. And I think it's a nice segue to the this last area of law, which is called the right of publicity, which is just the opposite. It's state driven. So there is no federal nationwide right of publicity statute. This idea, this right is governed by state statutes. Every state that has one is a little bit different. Some of them cover what's called post-mortem rights, meaning a right of publicity after you die. Some do not. Some require that in order to license your right of publicity to someone, you have to make a written license. Some do not. Some have an automatic fine for a violation. Some do not. So it varies state by state, but the general idea behind the concept of right of publicity is that every person, you don't have to be famous. Lots of people often think that this only applies to famous people, but that every person has the right to regulate the commercial use of their name and their likeness, sort of any indicia of who they are. And commercial use is usually where these cases are litigated. Someone takes a photo of someone and uses it, publishes it somewhere. If you publish it on social media because you think it's funny, is that a commercial use? Probably not. But if you're a brand and you publish it in connection with the sale or the promotion of your goods or services, is that use commercial? It may be, and that's going to create risk for you as the brand. If you're using someone's face, their voice, even an imitation of their face or voice, this comes up a lot. There was a whole series of cases for video games involving sports people. If you have someone who sort of looks like a pro athlete, the numbers one off, the names a few letters off, right? Are you entitled, or the game's entitled to use those people's likeness in connection with the sale of their games? It's the number of cases that have been litigated over that is staggering. I always like this example below with Katherine Heigl, because this to me also is sort of indicative of the social media age. This was in 2014, so long enough before Twitter and Instagram were as prevalent as they are now, and the rules of the road weren't as clear about, can you commit the same kind of violations in the digital world that you can in the regular world? The answer is clearly yes, but this example is Duane Reade, which is a pharmacy chain in New York. Somebody sold them a picture of Katherine Heigl leaving a Duane Reade with Duane Reade bags, and they thought, "Ooh, what a great way to promote our pharmacy brand!" And they tagged her in a tweet, trying to kind of connect her to the brand, and I think trying to create a nice little rapport with her, so that anyone who followed her, was connected to her, would then sort of be introduced to their brand. And she was not a fan. She was not on board. They didn't ask her. They didn't license the photo. They didn't ask her if they could use her. And so she sued. Now, she did arguably donate the money to charity. This was not, a money grab for her, as much as sort of one of the first real protests by, in this case, celebrities, of the sort of rampant use of likeness for commercial purposes without permission. And that comes up a lot.
And Duane Reade, right, would have for sure known, even in 2014, their advertising people would have known, I can't put Katherine Heigl or any other movie star in a TV commercial. I'm going to have to pay them. I'm going to have to sign all kinds of agreements. But social media, right, up until quite recently, it was a little bit of a wild, wild west, and people were kind of making up their own rules by the seat of their pants. But cases like these are a reminder that it's not a law-free zone by any means.
Absolutely. And this is certainly a case where, the technology and the culture is evolving so quickly and so rapidly and changing so much. Like, I haven't seen the first TikTok case yet. I'm sure there will be one, but that the law is just sort of slow and turtle-like. And so, people are doing their best to kind of apply it to the evolving landscape, but it's never quite a good fit. And I thought I'd maybe close out with a couple more real world examples that are fun and kind of emphasize how these are the kinds of issues that you always got to think about, whether you're a lawyer or not, but whether you're just somebody working in the world of putting together content, publishing content. This one this one sticks in my brain as sort of one of the first social influencer cases. Again, this is 2015. I purposely put the old-fashioned Instagram logo. That was the Insta logo back in the day. And this was before Instagram looked or felt anything like it does now. You can even see from the screenshot here that it was, much more Facebook-y and not nearly as curated or branded. The idea of an influencer didn't really fully exist then. But this was an FTC enforcement action, and this was sort of all the rage when it happened, because it was sort of the first evidence that this is how the FTC was going to look at their guidelines and their regulations in the context of social media. The backstory to this is Lord & Taylor, which may even be defunct brand, I think now, used social influencers to try and promote this dress, this sort of boho handkerchief dress. They paid these people, and they had a pretty clear contract about how much they were supposed to post, what they were supposed to say, what the images were supposed to look like. And Lord & Taylor did not include or require any disclosures, not unlike the gymnast mosquito case. Didn't require any disclosures that said, hey, by the way, I'm a hired influencer from Lord & Taylor. I'm making money. There's no disclosure. If anyone would look at this, they would think, oh, it's just an organic post by Happily Gray about her cool new dress. And the FTC knew, that struck the FTC as, no, that's deceptive. That is not a full disclosure of what's going on here. I think, too, maybe a kicker for this case was the added element that not only were there influencers on the payroll who weren't being required to disclose. But Lord and Taylor also sort of pitched the story to this online magazine, Nylon, and they wrote it, Lord and Taylor. In other words, it's a giant ad, and they paid Nylon to publish it. And Lord and Taylor had full rights and review rights for the story. So this was not at all an editorial piece. This was an ad very much made to look like an editorial piece. And again, no disclosures in the article that what we really have here is a paid advertisement by the brand to buy the dress. Anyone looking at this piece would be under the impression that this was really just kind of an organic editorial piece about the dress, which in fact it was not. So that was sort of the first shot over the bow to big brands, that if you do not follow the rules about native advertising and the rules about testimonials and endorsements in the form of social advertising, you could find yourself on the receiving end of an enforcement action from the FTC. I like to include this example too, because so it's not all doom and gloom. This is the flip side, and this is what makes this kind of work really difficult. This came up several years ago at the Grammys. Pharrell wore this hat as just part of his, outfit at the Grammys, and some, smart young digital person from Arby's spotted that and thought, ooh, what a great opportunity to try and, create a relationship with Pharrell and promote our brand. And if you're taking the Katherine Heigl case to heart, your first thought is, ooh, do not do that. That's signing yourself up for a lawsuit and a huge loss and a claim. But they went a different direction. They went ahead and did it anyway. Hey, Pharrell, can we have our hat back? #Grammys. And Pharrell, rather than filing suit, played into it. He didn't ask him for a license. He didn't charge him a bunch of money. He thought, hey, that's sort of fun. I like that. That's, I don't mind me a roast beef sandwich. And he engaged. And so for Arby's, that was a huge win. They got a lot of play, probably to an audience they wouldn't necessarily, have much access to. And Pharrell was a great asset to them without their having to license his image. And that was really kind of a calculated risk. So, in my world, I'm often, finding myself in a position of saying, well, that's pretty risky. You're talking about a Katherine Heigl situation, and the client is saying, yeah, but it might be a Pharrell situation. And that's a tough spot to be in, because you don't want to be the one who shuts down your client's ambitious, interesting, creative idea if, it could be that, but you also want to make sure that you're being prudent about actual risk. And this last one I always put up because it's near and dear to my heart, because I worked on this case and it was a total disaster and a great lesson for everyone in the field. The backstory to this particular image is that it was a page in one of those collector's editions of Sports Illustrated that is sort of glossy and thick, and in an old-fashioned world would be at the checkout at a grocery store. And I believe it was issued by Sports Illustrated when Michael Jordan was inducted to the Basketball Hall of Fame. And there was a deal between Sports Illustrated and the grocery stores that said, hey, if you'll give us free rack space for this sort of glossy magazine that we're putting out honoring Michael Jordan, we'll give you a free page in the magazine for whatever you want. So Dominic's, which is now a lot of defunct stuff I'm looking at in my Dominic's is a defunct Chicago grocery chain. And they put together, someone put together late on a Friday, I assume, their one pager to go into this magazine. And it really was intended as a tribute to Michael Jordan, right? That's his number, it's his name and his silhouette. And they say you're a cut above. The problem was they also added a coupon for a piece of steak. There's clearly a tie, you're a cut above, right? A reference to the steak. And the argument that Jordan made was, listen, you're using my likeness, right? My number, my name, my silhouette to try and sell your steak. And Dominic's response was, no, this is really just a tribute to you. This isn't commercial at all. it's separate from this thing down here. I'll tell you, the other grocery chain in Chicago had a much better case. Jewel Osco did not have a coupon on theirs. They had their catchphrase, "You're just like Michael Jordan, you're just around the corner." They also lost. In any event, we ultimately, as the grocery store chain, what's called admitted liability, we said, you know what, you got us. Okay, this is definitely a commercial use. And yes, we definitely did not license his name to do that. That being said, what's his real loss here? In Illinois, for each violation of the Illinois statute, it's an automatic $1,000. Or alternatively, you can prove with evidence how much you lost. Clearly, Michael Jordan was not going to take $1,000. Thus ensued a massive trial over damages, how much his brand is worth, what kind of deals he normally does, and how much he charges for them, and what the equivalent charge would have been if Dominick's had asked him to license his likeness. At the end of the day, that amount, according to the jury, was $10 million. So that was an unfortunate loss and a good lesson. Do not try and license Michael Jordan without his permission, particularly in Chicago, and do not ever try a case against Michael Jordan in Chicago.
The ultimate home court advantage, pun intended.
You got it. You got it. So that's, I would say that's a pretty good snapshot of what I do and the kind of fun things that come across my desk and the, important issues that I try and point out to my clients all the time to keep them out of trouble while they can still do creative and great investigative work.
Yeah. Oh, this is such wonderful information and such real world contemporary examples to show how practical it is to know a little bit about this law and also to know when you don't know enough and it's time to pick up the phone and call your lawyer before you get your client into $10 million worth of trouble. So thank you, Natalie Harris from Bear & Harris Healy. Really appreciate you sharing your expertise with us and a little glimpse into your law practice. So thanks.
Absolutely. My pleasure. Thanks so much for having me.